The first point, my lord, that I would like to urge for your lordship's consideration is that it is our submission that Shreya Singhal covers the issue. If we are right in our submission, my lord, there is nothing more that arises. If your lordship come to the conclusion that Shreya Singhal is against us, as is contended on behalf of the union, then again there is nothing more to be done.
So everything depends on Shreya Singhal.
No. If your lordship comes to the conclusion that Shreya Singhal is capable of interpretation either way, then, my lord, I have submissions to make to show to your lordships that independent of Shreya Singhal, what we are saying is right. That section 79 is not an empowering provision, and that section 79 is simply an exemption provision. And for that, my lord, I will rely upon several.
So are you suggesting that a provision for exemption cannot become an empowering provision?
Exactly. Yes, my lord. A provision for exemption cannot become an empowering provision. And a reading of the several provisions of the IT Act will indicate to your lordships, my lord, that where the legislature intended that it should be an empowering provision, they used certain words. And that those words are significantly absent in section 79. This is the first submission I would make for your lordship's consideration. Second, my lord, I would like to point out to your lordships as to why independent of Shreya Singhal, section 79 has to be construed in the manner in which we are saying, in order to ensure that 79 is not declared unconstitutional. Otherwise, 79 will face the same fate as 66A. And Supreme Court did not want to do it. Therefore, my lord, they saved 79 because they said, we are not going to read 79 as a standalone provision. We are going to read 79 along with 69A. And therefore, my lord, read down 79, read down the 2021 Rules 3(1)(d).
2011.
11, I'm sorry. 2011
was not in
No, I'm sorry. Yes. 2011 rules. And then, my lord, said, we are going to read down this in order to ensure that 79 is saved. Independent of this, my lord, I will show to your lordships that on a plain reading of 79, how it is not an empowering provision. And if the provision is read in the manner in which, my lord, the union wants your lordship to read it as an empowering provision, then, my lord, there are several enactments which I'm going to show to your lordships, which will become redundant. Then no need of any adjudication or decision under any of those enactments which declare a particular act as unlawful. Therefore, my lord, it is our stand that section 79 has 3 compartments, and one, of course, my lord, is knowledge on the basis of court order. Second is a decision that is taken under any other enactment. Third is a decision that is taken under 69A. It is, if these 3 are there or any one of the 3 is there, then if it is not complied with, then we lose the protection under 79(1). This is one aspect of the matter. The oft repeated submission on behalf of the union was 79 is only an option. We just told you
Options choice.
Options choice. It's an illusory choice. And as Supreme Court said, my lord, in the context of Article 29 and 30 of the Constitution, it is a teasing illusion. These are the words used by the Supreme Court, my lord.
Yes.
Is that a teasing illusion? And in fact, this has been, my lord, very clearly found in the judgment of the Bombay High Court.
Kunal Kamra.
Yes, my lord, Kunal Kamra. It is said so by His Lordship Justice Patel as he then was, and by His Lordship Justice Chandurkar as he then was at the Bombay High Court. I will point out.
Justice Chandurkar's view is affirmed by Patel's view is affirmed
by His Lordship Justice Chandurkar. Yes, my lord, that's right. So, my lord, that is one aspect of the matter. The other submission that was made was that it is advisory. Don't take it. If you don't take it, we are not going to do anything to you. you will simply lose the protection that is there under 79(1). What is the big thing that you're complaining about? Lord, there is an inherent contradiction in that argument. On the one hand, you say 79 is such a potent power that I have, and I want to deal with it for situations which are not covered under 69A, therefore I have empowered myself. Lord, you empower yourself to deal with an extraordinary situation, and then say, I leave it to you. You want to obey what I say? Obey. You don't want to obey? Don't obey. What happens to all that extraordinary situation which you want to take care of? It is that argument, my lord, therefore suffers from an inherent contradiction. You can't on the one hand say that 79 takes care of a very extraordinary situation. Look at it. It's so potent. It is so important that I must have this power beyond 69A. And then you say, I want to deal with extraordinary situations under 79, which cannot brook the delay under 69A, but then say, I leave it to your good wisdom. Whether you want to follow it, you don't want to follow it, don't follow it. That is, my lord, a patently wrong argument. And I'll demonstrate that to your lordships. Then, my lord, there was a wish list from the Union of India. I wish that Shreya Singhal had taken note of the development of the law. I wish. Yeah, exactly, my lord. That's what I was about to say.
You need not labor on that.
But I will independently
But
demonstrate.
execution of the wish there.
There, exactly. And in all fairness to the learned solicitor, my lord, he told your lordships that I
No,
want
that he fairly
I want to
admitted.
get Shreya Singhal referred to a three
Not,
judgment.
not here. He admitted that.
He admitted that. And,
So-
but in the process, a large or the major portion of the submissions was made on the development of law in the United States. How Reno is
Reno has
at
been
one end of the
subsequent-
spectrum, and how, according to the learned solicitor, other end of the spectrum is the judgment of the US Supreme Court in Paxton and the judgment of the US Supreme Court in TikTok. So if necessary, my lord, I will show to your lordships that neither Paxton nor TikTok takes a view different from what has been taken in Reno. This is independent of my submission that anyway today, my lord, whether US Supreme Court holds that Reno is wrong or US Supreme Court says Reno is right, insofar as we are concerned, Indian Supreme Court is right.
Shreya Singhal.
Shreya Singhal is right.
Yes.
That is the position. So, my lord, this is going to be the
Yes.
broad contours of my reply.
Yes.
Lord, we have prepared a
Kodi.
written submissions,
Yes,
my lord.
yes.
So, if your lordship's permission.
That's better.
Yes, my lord. So it will be focused, my lord. And
Makes, and I had asked Manu for the,
Pen drive is there.
yes, ಕೊಟ್ಟಿದ್ದಾರೆ Manu.
I will hand over.
Yes. And union also I asked. For
Give it to me.
pen drive of all the,
I will collect it and
yes, your response.
yes, I will.
no, my lord, I quickly run through this, my lord.
Yes, yes.
And I will try to be as brief as I can, but please bear with me, my lord, if I
No, no.
possibly, my lord,
No-
exceed your lordship's.
No problem, sir. You can,
Great, great.
I am
But-
all ears, so don't worry. Yes,
I mean, I have no doubt about it, my lord.
yes, sir.
I have no doubt about it, my lord. Petitioner ex corp places the following submissions for this honorable court's consideration. A correct reading of section 79(3)(b), loss of safe harbor, is dependent upon a preceding order. Either one, a court order, two, an order under 69A, or three, under a statute that specifically empowers information blocking. Well, the third one is very critical. I will show to your lordships, we have now got statutes where they say, notwithstanding anything contained in section 69A of the IT Act, intermediary shall remove if there is an order under this act. I showed your lordship that.
Yes, yes.
Within the meaning of section 79(3)(b, unlawful act must be read as referring only to those three
Circumstances.
circumstances. Respondents' argument that intermediaries have a choice whether or not to comply with section 79(3)(b) notices is incorrect because the consequence of non-compliance is loss of safe harbor, a statutory right, leaving intermediaries with no choice. Respondents have effective means to order removal of content online, that is section 69A, and its emergency blocking mechanism, that is my lord rule 9 which your lordship saw, as well as other statutes mechanism that empower issuance of information blocking orders. Rule 3(1)(d), the censorship portal, that is my lord Sahyog. My lord, it is very innocuously termed, my lord, but it is, if I may say so, a wolf in a sheep's garb. Rule 1(3),
Wolf in a lamb's clothing.
lamb's clothing.
Yes.
Exactly. The censorship portal and the impugned notifications are unconstitutional for the same reasons that 79(3)(b) should not be read to be empowering.
Next ಓದ್ಬೇಕಾಗಿಲ್ಲ ಬಿಡಿ.
Yes.
ಆ ಪಾಯಿಂಟ್ ಬೇಡ.
I know. ಹಾಕಿದೀವಿ ಅಷ್ಟೇ. I know.
Yes.
There is no dispute that the government can communicate with intermediaries to intimate that something in their view may be unlawful. My lord, we are not, I must tell your lordships, my lord, taking a confrontational position with the union. We are here to do business, and I am making it categorical for your lordship's consideration that we will do business according to the laws of this country. The question is, what is the law of the country? So, my lord, let us not therefore have any imputations being made against us that we are not willing to abide by the law of the country. We will abide by the law of every country where we operate. And we operate, my lord, in almost every country in the world. And of course, my lord, we will operate in accordance with the laws of India. And the question that your lordships are discussing, my lord, today is, what is the law of this country having regard to the constitutional scheme?
That is what is to be decided.
That is what is to be decided. That's what is to be decided.
No, even the learned solicitor did not say that you are not abiding. You won't abide by the law. You will abide by the law. Interpretation of
Interpretation of the law. There are some insinuations made that nobody is above the law and all that, my lord. I never claimed I am above the law. Nobody is above the law. Of course, my lord. Yes, I'm coming to it. There is no dispute that the government can communicate with intermediaries to intimate that something in their view may be unlawful. The government has the ability, like any citizen, to communicate this to intermediaries irrespective of the existence of 79(3)(b). The issue in this case is simply when such a communication results in the loss of safe harbor. That, my lord, is a crucial question. You don't want to give me safe harbor? Then it's a different scenario. Having given me a statutory protection, can you take it away in a manner not known to law? Law in this context, my lord, is the provisions of the IT Act, Shreya Singhal, and the Constitution. The government argues that whenever it merely sends a notice that content is unlawful in the opinion of any one of the thousands of authorized executive officers or police officers in every state, union territory, an intermediary loses safe harbor if it does not block the information from public access. This is an incorrect and unconstitutional reading of section 79 that has led to severe censorship of lawful information, news, journalism, and discussion of matters of public interest by the Indian public. It is pertinent to mention that the government adopted this interpretation only recently, 25 years after section 79 was enacted. As your lordship saw, my lord, section 79 came into the statute book along with 69A in 2009, was enacted. And 16 years after the current version of 79(3)(b) went into effect, thousands of officers at scores of central ministries, state, union, government agencies, and police departments throughout India now believe that 79 gives them authority to direct intermediaries to block content from public access, or else intermediaries lose safe harbor. X submits that consistent with the Constitution and the IT Act, an intermediary loses safe harbor under 79(3)(b) only if there is a preceding order, that is either a court order and an order under 69A, or an order under a statute that specifically empowers the information blocking, like section 14A(3) of the IGST Act. I'm going to show to your lordship this plot. I had not shown it to your lordships earlier. An intermediary receives the preceding order or is